This tutorial addresses the topic of legal research. The goal of this tutorial is to have you understand the fundamental tenets of legal research. One objective is to have you be able to identify and distinguish primary sources and secondary sources. Another objective is that you shall recognize when to use different legal sources in the research process. Finally, you will be able to recognize a source as mandatory authority or persuasive authority. If an area of law is new to you, you should begin with a secondary source, not a primary source. A primary source is the law itself. It's usually written by a government entity or official, such as a court, a legislature, or an administrative agency. Examples of primary sources include statutes, regulations and decisions, and case law. Secondary sources are not the law itself. They discuss and analyze the law. They provide commentary and terminology as well as citations to primary sources. They have a broad range of authors, including legal professionals such as judges and lawyers, scholars, and even law students. Examples of secondary sources include restatements, periodicals, loose-leaf services, ALRs or annotated law reports, legal encyclopedias, treatises and hornbooks, and dictionaries. This chart illustrates the steps you will take to do legal research. You start with a secondary source, and from the secondary source, you get your primary sources, your statutes, your cases, and sometimes regulations and decisions of administrative agencies. So now we'll discuss secondary sources a little more in depth. Restatements arrange the common law according to topic, along with commentary, illustrations, and notes. They're written by the American Law Institute, a group of legal scholars, lawyers, and judges. You've probably read segments of the Restatement of Contracts and of the Law of Torts. Annotated law reports are collections of essays that evaluate and discuss particular narrow legal issues. The most famous and thorough of these are the American Law Reports by Thompson West. Loose-leaf services deal with regulation-heavy topics such as Medicare, tax, or securities. The loose-leaf structure facilitates easy updating of these regulations. An example of a loose-leaf service is the Federal Tax Reporter. Periodicals include legal newspapers, law school journals, and law reviews, and bar association journals. They provide commentary and analysis of the current state of the law. Dictionaries define terms in their legal sense. The most prominent of these in the United States is Black's Law Dictionary. Treatises are book-length descriptions and explanations of a particular area of law. A hornbook is a one-volume treatise dealing with a topic addressed in a law school course. Legal encyclopedias are extensive compilations of articles on legal matters. The two major encyclopedias are Corpus Juris Secundum, or CJS, and American Jurisprudence, or AmJur. There are also encyclopedias that address state law. A good example of one is New York Jurisprudence. And you usually want to start with a treatise, a hornbook, or a legal encyclopedia, because they're more general discussions of the law. So let's look at how the Legal Encyclopedia American Jurisprudence works. This is section 138 of volume 45A of American Jurisprudence. It deals in job discrimination. At the very top, we see the title of this article, Sexual Orientation as Basis for Protection from Sex Discrimination or Transgender Status. The top half of the entry is a discussion of the law. Right away it mentions Title VII, so we know we are working with a federal statute. As we read through, we see important terminology such as sex stereotyping. Furthermore, we see discussion of case law with accompanying footnotes at the bottom and citations. A few to take note of are Price Waterhouse versus Hopkins, Ulaine versus Eastern Airlines, and Schroer versus Billington. A final important point on the last 2 pages. The entry mentions a decision of the Equal Employment Opportunity Commission, Macy versus Holder. I want to highlight this because later on I will use this case to demonstrate the relationship among statutes, case law, and administrative regulations and decisions. So now let's talk about statutes. The definition of a statute is a formal written enactment of a legislative authority that governs a city, state, or country that commands or prohibits something or declares policy. Statutes are written by legislatures. Here is an abbreviated version of how a bill goes through Congress to become a statute. First, members of Congress or the executive branch or outside groups write or draw up bills. The bill goes to its respective committee. A committee then tables, amends, or votes on the bill. This is where most bills die, but the fortunate few who survive committee go to the floor for debate and may be amended. Once a majority votes for the bill, it goes to the Senate. The process in the Senate is very similar to that in the House. A senator introduces the bill and it goes to a committee. If it passes in the committee, it moves to the Senate floor where it will be debated and amended. If a majority vote in favor of the bill, it returns to the House. If the House rejects these amendments, a conference committee of members from both houses drafts a compromise. Both houses must then approve this compromise. If they approve it, Congress sends the bill to the President. The President either signs it, in which case it becomes law, or the President vetoes it. If the President vetoes it, then it requires a 2/3 majority of both houses to become law. An estimated 25,000 bills are introduced during each term of Congress, and out of those, only about 10% become law. Federal statutes are published in 3 different ways. First, they are published as slip laws, individual statutes published in paginated pamphlets. These are referred to as public laws. They are also published as session laws. Session laws are the official collection of laws of each session of Congress. The government publishing office publishes these session laws in the U.S. statutes at large after a session of Congress ends. The last format of publication for federal statutes is codified law. Codes are for laws that are of a general and permanent nature. Codified law takes a couple of forms: the United States Code, Codified laws from 1789 to 1873 are covered in the revised statutes of the United States. The two annotated commercially published versions of codified laws are the United States Code Annotated and the United States Code Service. So now let's do a review problem. You go to the law library to begin your first assignment. Instead of librarians, you find zombies. When you ask a zombie for help in starting your research, they bring you 3 sources. You can choose only one to guide your research. Which do you choose? A statute, because primary sources come first. B, corpus juris secundum, because it is a secondary source with broad coverage of a topic. Or C, a legal periodical, because it is a secondary source dealing with a narrow topic of law. The answer to problem 1 is B, corpus juris secundum, because it is an encyclopedia with brief explanations of the law and footnotes to primary sources. Answer A, statute, is incorrect because you don't start with primary sources. C, legal periodical, is incorrect because a legal periodical offers detailed commentary of specific areas of the law and legal areas. They can be very theoretical. So now let's talk about case law. Think of statutes as the bones of the legal system, and cases flesh out and interpret those statutes. Case law is defined as the body of reported judicial opinions comprising the law within a particular jurisdiction. A fundamental pillar of case law is the doctrine of stare decisis. It literally means, let the decision stand. When it comes to judicial opinions, it means that courts must follow similar past decisions or principles to reach conclusions. These past decisions are precedent. Whether a case is mandatory authority or persuasive authority depends on the relationship between the court about to make the decision and the court that made the precedent. Mandatory authority means that courts must adhere to decisions of higher courts that are in the same jurisdiction. Persuasive authority refers to sources that can influence a court in deciding a case. They are not binding authority. It is important to communicate why a court should follow persuasive authority. Reasons can include statutory language and public policy considerations. Another explanation could be that all other courts who have heard this issue have decided it the same way. Still, other reasons are that the decision from another court is factually identical to the case being decided, or it is the most current authority available on the topic. Now let's look at the federal court hierarchy. All courts, whether federal or state, must follow decisions of the Supreme Court. At the federal level, under the Supreme Court, are 12 circuit courts of appeal and 1 U.S. Court of Appeals for the Federal Circuit. The U.S. Court of Appeals for the Federal Circuit is the only appellate-level court with jurisdiction to hear patent court appeals. The other 12 circuit courts oversee 12 circuits or regions. Underneath these 12 circuit courts are 94 trial or district courts. Now let's look at the hierarchy of case law in New York State. The Court of Appeals is the highest court in New York State. Underneath the Court of Appeals are 4 appellate divisions, 1 for each of the state's 4 judicial departments. Under the appellate divisions are the Supreme Court, county courts, and miscellaneous trial courts. You can find case law, whether federal or state, in a series of books called reporters. There are 2 types of reporters. Official reporters are publications approved by the government. Unofficial reporters are published commercially by companies such as West. The United States Reports is the official reporter for the United States Supreme Court. The unofficial reporters for the Supreme Court are the Supreme Court Reporter, published by West, and the United States Supreme Court Reports Lawyers Edition, published by Lexis. Federal Circuit Court decisions are published in West's unofficial Federal Reporters, Federal Reporter Second Series, and Federal Reporter Third Series. A selection of federal trial or district court cases are published in West's Federal Supplement or Federal Supplement Second Series. In addition, West publishes only state appellate level opinions in several regional reporters. These are the Atlantic Reporter, Southeastern Reporter, Southwestern Reporter, Southern Reporter, Northwestern Reporter, Northeastern Reporter, and the Pacific Reporter. For New York cases, you are required to cite to the official reports published by the New York Law Reporting Bureau. The reports include cases of the New York Court of Appeals. There are also the Appellate Division reports, and the New York Miscellaneous reports contain a particular selection of trial court decisions. In addition, West publishes several reporters based on subject. They are the Bankruptcy Reporter, Federal Rules Decisions, Military Justice Reporter, and the Federal Claims Reporter. Administrative law is another important topic in legal research. Administrative law includes rules, regulations, orders, procedures, and decisions made by agencies. Agencies can put rules, regulations, and orders into effect. This is described as their quasi-legislative role because it is akin to legislature's ability to promulgate statutes. Statutes, however, are usually broader than regulations. Agencies also exercise quasi-judicial authority when they hold hearings and make rulings and decisions. The Administrative Procedure Act, enacted in 1946, sets out the standards and procedures for making rules and guarantees public participation in the rule-making process. Proposed rules and final rules are first published in the Federal Register. The Code of Federal Regulations is where the codification of rules and regulations are published annually. They are arranged by topic. Examples of administrative agencies include the Environmental Protection Agency, the Securities and Exchange Commission, the Equal Employment Opportunity Commission, and the Central Intelligence Agency. Now we should discuss the relationship of administrative law to statutes and case law. The Supreme Court case Chevron USA versus Natural Resources Defense Council addressed the question of which standard of review a court should apply when dealing with an administrative agency's interpretation of a statute. The Supreme Court devised a two-step test. The first step is to ask whether Congress has directly spoken to the exact question at issue. If it has, then the court and agency must adhere to the clear intent of Congress. If Congress has not directly addressed the question at issue, then go to the next step. If Congress has not directly addressed the question, the court must evaluate whether the agency's decision is grounded in a permissible construction of the statute. Courts widely consider agencies to be persuasive authority because they have expertise in a particular area, such as employment. So let's go back to the EEOC case we found in American jurisprudence, Macy versus Holder. The encyclopedia noted that in this case, the EEOC decided that when an employer discriminates against someone because the person is transgender, the employer has engaged in disparate treatment related to the sex of the victim. In this area of law, the EEOC's holding is at odds with some court decisions that transgender status is not a basis for sex discrimination claims under Title VII. The EEOC's holding is persuasive. It does not bind the courts. Our first example. The Central District Court of California is deciding a case about whether an employee endured sex discrimination in his employment based on his transgender status. Neither the Supreme Court nor the Ninth Circuit has ruled on the issue, and it's a case of first impression. At this time, a similar claim has failed in the Second Circuit. On the other hand, the EEOC has recently decided that a claim based on transgender status can constitute sex discrimination. Which must the Central District Court follow? A, the Second Circuit, because it's a higher court. B, the EEOC, because it's an agency with expertise in a specific field. Or C, it doesn't have to follow either one. The right answer is C. The Second Circuit is a higher court, but it's not in the same jurisdiction, so it's only persuasive authority. Remember that for a case to be mandatory authority, it has to be the decision of a higher court in the same jurisdiction. The EEOC is an agency with expertise in the specific area of employment law, but its decisions are not binding on courts, so it too is persuasive authority. Example 2. The county court in Albany is deciding whether a prison improperly denied an inmate's request for conjugal relations with his wife. The Court of Appeals has not ruled on the issue. The New York Supreme Court Appellate Division, Second Judicial Department, has held such a denial to be improper in a similar case. The New York Supreme Court Appellate Division, Third Judicial Department, has upheld a similar denial in another case. Which, if either, does the county have to follow? A, the Second Department, B, the Third Department, or C, neither, because the Court of Appeals is the highest court in the state. The correct answer is B. Remember, for a case to be mandatory or binding authority, it must come from a higher court in the same jurisdiction. The County Court in Albany is under the jurisdiction of the Appellate Division, 3rd Department. While the Court of Appeals is the highest court, decisions of the Appellate Division, 3rd Department are also binding on the County Court. So here's our discussion question. Stare decisis means that judges and lawyers must follow the decisions of higher courts in similar cases. This doctrine has provided stability and predictability in the law. However, it has also allowed erroneous decisions to continue to determine law and impeded beneficial changes in the legal system. It is not absolute, and precedent can be overruled. Why and in what circumstances should precedent be overruled? What public policy considerations, if any, should be taken into account?